Nurse Ali in the CCU to see the patient. So that would actually point to the direct opposite of conscious indifference, that he was very concerned about her safety. And that also, on top of the facts and what that evidence shows, with Dr. Barone's declaration being conclusory, there is case law that states that a conclusory affidavit from an expert is not sufficient, evidence to create a fact dispute in a summary judgment motion. And for gross negligence, the plaintiff must also have expert testimony from an expert that Dr. Modi was negligent. And we would argue, Your Honor, that there is no evidence from Dr. Barone in his declaration or in his deposition wherein he says that Dr. Modi was grossly negligent and proves up those objective, subjective elements for a gross negligence claim.
Okay. Response?
Morning, Your Honor. There's a couple of different things that I'm going to need to respond to, and I'm going to try to take, starting with the most recent one, this need for expert testimony. I want to give the court just a brief roadmap of these specific points. I'm going to start off with explaining how or why proving gross negligence doesn't require expert testimony under Chapter 74 or the case law that followed the enactment of Chapter 74. Second, that even though expert testimony isn't required to prove gross negligence, plaintiff provided that evidence, and it was based on reliable foundation in both Dr. Barone's expert report as well as the declaration. It's not conclusory simply because he reached a conclusion. And finally, that aside from those opinions, when you look at the facts of this case and the evidence that's attached to our motion, specifically the timeline of events that shows the progression of her symptoms in the ED, and then later on in the CCU, coupled that with Dr. Modi's own testimony, a reasonable juror could conclude that he was grossly negligent. Ms. Mazar made the point that the evidence attached doesn't prove that he was grossly negligent. I don't have to prove at the summary judgment phase that he was grossly negligent. I just simply have to present evidence that raises a fact issue that a jury could latch onto and determine that that was grossly negligent. So I just want to point that out to start with. And going to the first point, that gross negligence doesn't require expert testimony, Your Honor, that's really, if you look at the reply brief that defendants filed, that's really what they're basing their summary judgment on, is a lack of expert testimony to prove gross negligence. However, the authorities relied on by defendants in this case all predate the enactment of Chapter 74. And when you really get down to the root opinions that support their position, they actually don't stand for that. They require expert testimony to prove ordinary negligence, not specifically gross negligence. But there is a case out of the Houston Court of Appeals after the enactment of Chapter 74 from 2011 called the now Zaradin versus Rhines case. And the court went through the entire analysis on what expert testimony is required under Chapter 74. And they explained that gross negligence is nothing more than a heightened degree of the ordinary standard of care. And I want to, if I could, share my screen with the court on this opinion.
Sure.
I think it really just nails this issue down. You can see here on the right here at pages 741 to 742, it states that our conclusion is consistent with the language of section 74.351, which requires an expert to opine regarding the manner in which a physician breaches the applicable standard of care and the causal relationship between that breach and the plaintiff's injury, not the extent of the breach. And the court goes on in the green highlighted portion to analogize this to some sister courts who have analyzed this in the context of the emergency medical care standard that requires a gross negligence finding. And the court specifically said that a plaintiff is not required to provide an expert opinion supporting the willful and wanton element in cases involving emergency medical care, because such proof relates to the degree that the physician or healthcare provider deviated from the standard of care. And in this context, what this opinion is, it also goes on, you can see over here on the left side at 741, it's talking about gross negligence in the context of exemplary or punitive damages, which is relevant here. defendant's motion essentially puts the cart before the horse, because exemplary damages only become available after a finding of ordinary negligence and actual damages. Their summary judgment does not attack any element of plaintiff's general negligence claim. And so to dispose of this claim or exemplary damage claim before any evidence presented to the court and to the jury is really premature at this point. But in sum, the case held that one, Chapter 74 doesn't require expert testimony for gross negligence, and two, gross negligence is simply just a heightened degree of a breach of the ordinary standard of care. So,
Ms. Mazur, is there any cases that are post Section 74 out of the Dallas Court of Appeals or Supreme Court that address this issue?
Not that I have available to discuss right now, your moment of the honor, but I'm happy to provide supplemental briefing to address that specific issue.
Okay. Anything else, Mr. Bullard?
yes, Judge. Just want to continue on to the second point about the fact that plaintiff actually provided expert testimony in this case that Dr. Modi was grossly negligent, and it's based on a reliable foundation. The court reads the declaration. It lays out what the applicable standard of care was, the facts that Dr. Verone believes Dr. Modi breached that standard and that it caused the injury. And in doing so, he believes that that breach was such of a heightened degree that results in gross negligence. This word conclusory that is being thrown around is a buzzword that defendants like to use as if it has some merit, when more often than not, it's really meaningless. I mean, if this was truly a conclusory opinion, and the court can read the declaration for itself, it would simply be, I've reviewed all this information and Dr. Modi was grossly negligent. That is not the case here. So even though we're not required to produce expert testimony on this issue, we've done so, and it's sufficient to raise a fact issue. But aside from Dr. Verone's opinions in this case, there's evidence from Dr. Modi's own testimony, as well as evidence in the record that a jury could find that he was grossly negligent under both the objective and subjective prongs. And I'm not gonna go through line by line of our briefing. I know you read the briefs. I'm just gonna try to hit the high points as fast as possible. We know that in the standard of care here, the first thing to do is assess the airway. In Ms. Murphy's case, it required intubation based on her severity and the extreme risk that she was presented with. There is no dispute that the most extreme risk this woman faced was a total airway collapse and brain damage, which is exactly what happened here. The best evidence that Dr. Modi objectively knew this is the first thing he did was he ordered a surgical trach kit be placed at her bedside. He anticipated what eventually happened, yet he didn't do anything to protect her from it. And a jury could easily conclude that satisfies the objective prong. Under the subjective element here, was, as the court is well aware, involves the defendant's state of mind, which is why the Turner Court of the Dallas Court of Appeals has explained generally gross negligence in this context, because it involves the defendant's state of mind, is more often than not inappropriate at the summary judgment stage. It's a very fact-intensive issue. And here, Ms. Mazar explained or discussed the hour to hour and a half after the medication has been administered issue. Importantly, Dr. Modi was aware that medications had been administered in the ED. And although he was incorrect on the time, he believed they were started about 9 a.m. Then he says, if there was no improvement within an hour to hour and a half after these medications have been administered, I would have then advocated for intubation. Well, that deadline came and passed under his care, and yet he didn't do anything. A jury could easily determine that he knew the risk. He proceeded with conscious indifference because simply he didn't care. So the fact to say that there's no evidence in this case just simply ignores the facts, and the court can look at the timeline and for itself that it's derived from the medical records in this case, and see that Miss Murphy was not improving. The fact that her airway continued to collapse and ultimately collapse is evidence of that itself, despite all of these medications. And so, Judge, in sum, we have plaintiffs would argue that gross negligence doesn't require expert testimony, even though we've provided it, and it's not conclusory. It's based on reliable foundation, which the court can see. and there's been sufficient evidence to raise a fact issue that a jury could conclude Dr. Modi was grossly negligent. And so we ask that the court deny the motion.
Ms. Mazur?
Yes, Your Honor, just a brief rebuttal to Mr. Bullock's argument. I would like to point out that the case law that we did cite in our reply, just to emphasize our objection, that it is our contention that Dr. Barone's declaration is conclusory, and conclusory affidavits are not sufficient evidence to create a fact issue in a summary judgment motion. And what we did also put in our initial no evidence MSJ is a portion of Dr. Barone's testimony wherein he agrees that this is not a case of neglect, wherein somebody was acting with conscious indifference to the safety of Ms. Murphy. And that was in our initial no evidence MSJ. And the other testimony from Dr. Barone that is important here is that Dr. Barone agreed that in the ED, when Ms. Murphy was in the ED, and that by 8:45 a.m., and I'm happy to also pull up this testimony, Your Honor, if I can find the exact page number. Okay.
I'm not sure what's going on with your Zoom, but your voice is not matching up with. It's like watching a foreign film where the translation's not, you know, when they dub in English and it's not exact. I don't know what's going on with your Zoom, but it's not a big deal.
Is there a slight lag, possibly?
Yeah, there's a lag. It's essentially.
I feel like you're watching the Squid Game, Your Honor.
Yeah.
I was trying
Very good description of that.
Sorry to interject.
Does this mean Peter's going to come in and shoot me after this MSJ hearing? Is that what the Squid Game is right now?
It is a little distracting. It's fine.
I'm sorry. Well, I'm about to share my screen, so hopefully that distraction goes away.
Okay.
Let's see here. Okay. I'm just sharing a portion of Dr. Barone's testimony here. This is on page 137. The question is, having read Dr. Armstrong's deposition, do you agree with him that intubation was no longer a possibility by 8:45 because it was likely to fail? As I said, his answer, as I said, it was, if we are talking more likely than not, more than 50% chance of failing, that is correct. So our contention here, Your Honor, in pointing out this testimony would be if plaintiff's own expert is agreeing, that by 8:45 a.m. after on, no intubation would have been successful after that and was likely to fail. I'm not sure how you can then argue that Dr. Modi was negligent, let alone grossly negligent, by not advocating for intubation that plaintiff's own expert is saying would fail in the CCU after 8:45 a.m.
Let me tell you, I wanted you guys both to have a chance to argue because I know you're both young lawyers and you guys don't get a chance to do this. I deal with this issue on gross negligence pretty much the same in almost every case, which is I deal with it at the charge conference. And so we'll kind of see what the evidence is at trial. I think there's enough to get to a jury on this. That doesn't mean that you shouldn't raise this in a directed verdict. I'd say in about 50% of cases, I end up granting a directed verdict at that point. Anyway, so for now, I'm going to go ahead and deny the summary judgments. Very good arguments by both sides, despite the lag, the Squid Games lag, but very good argument, very good briefing on both sides, and excellent advocacy by everyone involved. So have you submitted orders, Mr. Mitchell or Mr. Bullard?
If I haven't, I will. And
do you know, Mr. Mitchell, if you have?
I don't know.
Mr. Bullard.
I believe you. I think they came in yesterday. I'm pretty sure I saw them come in.
Let me just check.
Only thing I would add, Your Honor, I thought the briefing by all the parties was very good. I do have to state on the record that Mr. Bullard did all of our briefings. So to the extent the court thinks that briefing is above average, then by stipulation, that is Bullard's work, not mine.
Well, that it was, both sides was definitely well above average. So all sides are to be commended. Let me just make sure I have an order on this. Okay, it looks like we have an order here denying Dr. Modi's motion. Why is this not coming up? It's confusing. Why is this not coming up? Okay, okay, I found that order. Let me see if I can find the other order. Oops. Did I just close the Zoom? Are you guys still there?
Yeah, we're there.
We're here.
Okay. Let me just see if I have the other order. Sorry to keep you waiting. I just want to make sure I have all the orders. Great.
Your Honor, we can submit an order because I doubt we have on excluding Dr. Armstrong's testimony, or if it's easier, we may just have a agreement with Mr. Mitchell that that's their intent not to call him. So we will.
There
either-
is an order, I believe, for Armstrong's granting it.
Yeah, Your Honor, if I may, just on the record, we would just de-designate Dr. Armstrong. So, and we can put that on the record. I don't want to have some kind of order out there that he's not qualified, but I didn't respond to the motion and he gets mad at me because I didn't respond to it. And there's some order out there saying he's not qualified. So I just want to de-designate him as an expert on the record, if that's acceptable to the other folks.
Yeah, I would be fine with that, Jim.
Yeah, thank you, Peter.
Maybe it should say something like he's de-designated with prejudice, that he can't be.
Yeah,
that can't be reconsidered, because it really wouldn't be fair to them if they.
that would be perfect, Your Honor. That's a good suggestion. I'll let Ms. Mazar or Peter draft an order, and we work together well. I'm sure we'll come up with some agreeable language that protects them and satisfies the court.
We can do that.
You may have submitted one. I can't find it, at least.
It looks like it was submitted on November 24th, if that helps. The one denying my motion, if that's the one you're looking for.
Yeah, that's what I'm looking for, November.
Yeah, it looks like it was
Yeah,
submitted.
maybe this is it. Let me see. The one on exemplary damages.
That's the one against us.
Okay. I think that's Dr. Modi's one, right?
Yes.
What's going on here? Why is this not working? I apologize. My computer is just not cooperating with me today. Anyway, I haven't been able to find the other one. So why don't you just, if you don't mind, emailing a copy of, well, let me see. I finally got back to where I was supposed to be. Yeah, I just don't see the one for Dr. Sheffield. What day was that one? You said that was the one on the 24th?
That's what I have on my system. It might have been filed on the 23rd, but went through the process on the 24th.
I don't see it on the system. I see Dr. Modi's one. So if you could go ahead and e-file that again and email it to the court, and we'll go ahead and get it signed.
I'll have Mr. Bullard take care of that. Thank you, Your Honor.
All right, guys, you guys have a great rest of your week and weekend, and happy holidays. And we'll have you guys gone to mediation on this case yet?
Well, we mediated. There was 5 defendants. Now there's only 3. We mediated several months ago with Joel Steed, and we're able to resolve 3 of the 5. And there's some little bit unique issues with the 2 remaining that are holding up. I would let Peter and or Mr. Campbell decide whether another mediation is appropriate, but there's some unique issues that they may think it's not warranted. But
Y'all want to? I mean, let's go off of YouTube to discuss this. What are you guys here for?
We want to see if we can get married today here.
No, I can't. I'm so sorry. Not today. But good luck, okay?
There's no way. We got everything ready. So what do you have to do is sign everything.
I'm in the middle of a hearing, ma'am. I'm so sorry.
Man, sir, y'all need to step out. He's in the middle of a hearing on Zoom. All right, he can't do it. There's another district judge. You go 2 floors up.
Sorry, guys.
I actually misspoke. Joel Steed didn't mediate it. He was one of the defense lawyers. Adam LaCrone mediated it, but Joel Steed ended up kind of mediating it.
Right, good point.